I'm happy to throw to Dr. Patterson. Yeah.
Patterson.
Thank you. Minister, you at the beginning of the year held the market sounding process for the costing of the central monitoring system. I was wondering if you could let us know how much this system will cost. What was the quotes that came back through the market sounding process?
Thank you, Dr. Pass. I have sought advice on that from the agency, and the advice I have is that it is not normal to disclose that information, both from a procurement point of view and a probity point of view, and that the risk is of undermining a future procurement process. These are bids are not the right word because it's not a procurement. These are inputs that have been provided by these companies on a confidential basis, and I'm not in a position to disclose it.
What about a public interest?
Perhaps I can have Mr. Ng explain in more detail the existing rules.
Yeah, no worries, Minister. Yeah, Dr. Patterson, yes, the advice that we have taken from within government that is not regular to fully disclose the outcomes of market sounding processes. There are two streams to considerations there. One is that, as the Minister has indicated, it may prejudice future competitive activities of government. So, to the extent that the government is seeking the best value for money proposition if and when it does go out to market, the disclosure of the costs that have come back in the market sounding process may prejudice the outcome of those. The other part, which is a factor in the disclosure of the precise responses in the market sounding process, that some of the organisations which have submitted a response to the market sounding process may have commercially sensitive material that they've submitted back. That process was a research exercise, one which was intended to support government with a better understanding of the capacity of the market to deliver a product of the nature of the central monitoring system. And so part of the technical investigations that process was intended to elicit may contain commercially sensitive information for some of the organisations which submitted a response.
So in your...
Can I just check?
Yeah.
Minister, are you claiming confidentiality, and can you explain the harm to the public interest that could result if you disclose that information?
Thank you, Madam Chair. I think the points that Mr. Ng has just made are the key points that I would rely on. There is some answers I can provide, and I will endeavour to as the questioning goes on, but I think the points that Mr. Ng has just made are the ones that I rely on.
Can you explain where the harm would accrue from providing that information as confidential evidence?
Well, again, I think it goes to the points around confidentiality of commercially sensitive information. It's the same approach the government has taken on, for example, the light rail contracts, and Mr. Steele has provided extensive explanation of the same matters around the importance of government achieving value for money for taxpayers in the ACT if we are to go to procurement.
Minister, I recently FOI'd some documents on the central monitoring system, and some of the advice through those documents stated that the government doesn't have to go through a procurement process to take on board to procure a central monitoring system. So I guess knowing that it actually is quite a different process than the light rail process, I'm wondering, and going to your comments before about not being able to fully disclose, is there some level of disclosure that you can provide to the community about what this will be costing, given that it is, the entire parliamentary and governing agreement, gaming reforms are premised on the cost of this monitoring system?
Yeah, I am currently seeking advice on what information I can release. I don't have that available at this time.
Can I just continue? You've said that even providing the material confidentially may be not in the public interest. Can I remind you that public interest overrides claims of commercial confidentiality? I'll ask the committee whether we wish to deliberate in private or whether we're satisfied with the Minister's explanation.
I'm satisfied. the Minister's explanation? Because I understand that procurement's currently in process. Is that correct?
Not at this point in time. The government's currently taking a decision on how to use the information that's been provided to shape the next steps.
I'm also satisfied with the explanation.
Okay.
Can I ask one more question?
You may.
So at the beginning of this process, there was lots of discussion that CMS in the ACT would be a similar costing to that in Tasmania of $70 million. You recently came out in publicly and said that a CMS, the market sounding had shown about half the expected costs. So you're willing to make comments like that publicly about the cost. Why can you not disclose even a range for the committee in terms of what it costs? Because you know full well that saying that it was half the cost is very leading in terms of what it may cost.
The information I was trying to convey there was that what the market sounding has usefully revealed as part of the research that Mr. Ing was referring to is that the ACT will not need to replace machines across the board, and that will substantially reduce the proposed cost of it. So I think I'm trying to convey what I can, and that's why I've spoken about it in very general terms, but the positive news has been that the early research undertaken by the agency indicated the necessity of replacing a lot of machines. The new advice and the new information we have is that will not be necessary, which does substantially reduce the cost.
Notwithstanding the committee decision, I do find it very interesting that you feel able to make public comment about a ballpark figure, but you're unable to provide that information publicly or confidentially to a committee of the Assembly on a direct request.
As I indicated, there is some information I can provide, and I was getting to that, but I was asked a very specific question about the cost, which is, I was asked to provide actual numbers. I've now tried to share with Dr. Patterson the information that I can to help the committee understand the issue. I'm trying to walk that careful line between sharing what I can, but respecting the concerns that Mr. Ing has outlined.
Are you able to put on notice the exact concerns regarding, given that the advice I've seen is that it's not a procurement process, the exact concerns regarding disclosure of the cost?
Dr. Patterson, if I could just pick up the point in relation to the nature of the exercise. Yes, the consideration within government is that it would not necessarily be a procurement exercise. That doesn't necessarily obviate a process around ensuring that there is value for money out of the arrangement, and so there's a range of there's a range of processes which apply to testing the market response. Should government go out to market formally to see what the kind of price points that the market would come back at, and so while it's not a procurement in the sense that government would be purchasing a product in the sense of the Procurement Act, that doesn't mean that there won't be a value for money process that is undertaken to ensure that the response to any market approach, formal market approach, is the kind of cheapest and best approach that's available.
Yes, if I
Supplementary,
could,
Mr. Parker.
Chair. Mr. Rattenbury, after the election of 2020, as was pointed out by Dr. Patterson, this component was front and centre in the power sharing agreement, and I think that there was an expectation from many, probably including yourself, that we would be much further forward in this process now than we currently are. What's been the biggest single stumbling block in the process to implement a central monitoring system?
Mr. Parton, there's been a number of things. First of all is the agency has done extensive research and consultation. That's taken a fair amount of time, as I think I've canvassed with this committee before. So understanding the technical answers has been a significant part of it. And the second key, I guess, time cost has been internal government decision-making processes, stepping through cabinet subcommittees and the like.
All right. And just finally on this line, Chair, if I could, I'm very familiar in dealing with hypothetical numbers in regards projects of this government, and certainly based on the media comments that Dr. Patterson referred to, the ballpark figure that I'm working on, whether or not you're prepared to say it, is sort of somewhere between 35 and 70 million. I don't want you to confirm that, but what's the expectation from you as to how that's going to be funded? Where's that money coming from?
There's a number of ways it could be funded, both in terms of time and source, if I put it that way. But the time factor is, for a procurement like this, you can operate on a model, not unlike light rail as it happens, where essentially it's a fee for service over time. So the provider would pay for the installation to avoid upfront costs for the industry, and then that gets amortised over a 15, anywhere between 10 and 20 year contract. And so on a monthly fee basis, for example, and the machine operators would pay for that.
So the clubs would pay for it over a period of time?
Potentially, yes. Yep. That's one model.
Yep.
There's a range of models. Government could pay for the capital costs up front, and then the clubs could pay the ongoing service fee. So there's a range of different models available.
All right. Okay. Thank you. Thanks, Chair.
Thank you. No further supplementaries. That was Ms. Oars. Ms. Nuttall.
Similar topic. Why did you go down the option of proposing the central monitoring system in the first place?
Well, the government has undertaken extensive research, and what's come back is that a central monitoring system is the backbone that permits the critical harm reduction measures such as mandatory pre-commitment and default loss limits. These are considered to be essential harm minimisation measures, and this harm reduction proposal enables individuals to be supported towards a low-risk gambling environment. But we are the only jurisdiction in Australia that does not have a centralised monitoring system. The CMS, there's been suggestions in this place before that it's sort of a focal point. It's simply an enabling tool. It is a tool that provides the connection to enable a universal harm reduction system. What, for example, Victoria has learned, where they've brought in these sort of measures, is that if you don't have a universal system, somebody will just walk out of one venue having hit their limit, and the casino, for example, has limits, and they'll walk into the next venue and resume their gambling. If they've put in place a pre-commitment, they then reach that limit and are able to go somewhere else. It becomes a reasonably self-defeating system.
Thank you. What are there alternative models for proposals for regulating the pokies that have been promoted to the community, and what would be your assessment of those alternative models?
Certainly this is the proposal I've put forward to the community. It's supported by a range of key organisations, so all the experts and advocates you talk to will support a model like the government, like that I'm putting forward to the government. ACCOS said it earlier in these hearings. The Canberra Gambling Reform Alliance has supported it. The National Alliance for Gambling Reform has supported it. The AE Centre for Gambling Research supports it. So that's the basis on which we've put this proposal forward.
Just one more if that's okay, sorry. What is the reception among harm reduction advocates for CMS, particularly with the carded play and mandatory loss limits? Is that sort of, we spoke broadly, but specifically on those points?
Mm-hmm. Certainly the advocates make the point that if we are really curtail risk in the gambling environment, having both loss limits, having some sort of prescription of what those limits should be, and making them universal are the critical features. This is, going back to my earlier point, if you can simply walk from one venue to the other and keep going, then you are having a system that's just full of holes. And that's the important point, and why they think being able to link the machines up is so important.
Ms. Dr. Patterson.
Minister, do you understand why the club sector, why many of us are really confused with this situation when we started this conversation around bet limits and load limits as part of the parliamentary and governing agreement? To do that, you needed a CMS.
Yep.
You said in a recent gambling symposium that you quoted ANU research saying that bet limits and credit limits result in little to no reduction of gambling harm. We've then morphed into, starting point, have you abandoned bet limits and load limits as a policy in the ACT?
Well, thanks, Dr. Patterson. I understand that this is a difficult space for the Labor Party, who are impossibly compromised by the fact that they own more than 400 poker machines in this city and take over $20 million a year in gambling losses from the campus community.
That was not my question.
So I understand the difficult space that you're in.
Direct for Minister Howe to answer.
What I would say is that that policy position was based on the best advice that we had prior to the 2020 election. Having looked further at it, the advice that has come in is that there are better ways to approach this, and so I've been open enough to receiving new advice and the evolving understanding of how the space works to take that advice from the key advocates.
So what measures specifically did you go to the market sounding with the CMS proposal to see implemented in the ACT?
Yeah, Dr. Patterson, I would say in broad terms that the Directorate's been funded to investigate and explore the feasibility of the introduction of a central monitoring system, and so I think that's reflected in the budget papers. And so the market sounding exercise was broadly to seek views from the market about the capability of the market to deliver a central monitoring system, and there were a range of technical capabilities that we also sought advice from the market about whether they could deliver as part of a central monitoring system.
Could you outline them for the committee?
I don't have them directly to hand, Dr. Patterson. I'd be happy to take that on notice. I would take it on notice in the context as well, though, that as we've discussed at length in this hearing, there are potentially limits to the extent to which we disclose all the documents. I certainly have to take it on notice and see what we can provide.
Minister, do you understand that it's very difficult when no one knows where we're heading or why we're heading in this direction, that a CMS has become the central point of this discussion, which it should not be? It is not a harm reduction tool.
I've never claimed it is a harm reduction tool. You're putting that argument, Dr. Patterson. You've been the one who has made that public assertion. I have never made that public assertion. We're simply using this as a tool to facilitate harm reduction measures.
What, though? What harm reduction measures?
Well, the harm reduction measures we're specifically focused on now are mandatory pre-commitment, gambling losses, and jurisdiction-wide player card gaming to ensure that we can put harm reduction, those recommended harm reduction measures in place.
And when did that change? Going from bet
Through the course of the
limits?
research that we've undertaken in the last couple of years.
Ms. Orr?
Yeah, the chair's just indulging me because I didn't want to call a point of order, but Minister, I appreciate this is a topic that has some more robust discussions in this place. But I think in one of your answers you mentioned that the Labor Party owns poker machines, and I think it's a little bit more nuanced than that. I think you find it's the Labor Club that owns them. I just asked that in answering the question, you just, in the heat of the moment, try to take on the nuances that are there so we're keeping it all factual and well represented.
The opaqueness of that matter does make it challenging to get it just right, is all that I'll do my best.
Thank you.
Thank you. I have a follow-up. I know that Dr. Patterson was talking about how clubs find it uncertain, not knowing what's going on, and I know Mr. Parton has mentioned that often in his discussion with the clubs that they find it difficult to diversify because of time it takes for development approvals and things to go through. So the clubs are in this constant state of not knowing where to go and how long it's going to take them to do anything. Do you have a particular view? Do you agree with that assessment by the clubs, and how can we make it easier for them to move forward in this space?
Look, we've seen, I established the Community Clubs Ministerial Advisory Council at the start of this term to create an ongoing dialogue between the government and both the industry and harm minimisation advocates, and also for them to be able to talk to each other. They're all represented on that group in order to create dialogue and understanding. We've published many documents, we've had a range of working groups, so there's a clear channel of communication. On the point of diversification in particular, I've certainly heard that feedback from the industry. I've approached the planning minister to provide a concierge to the clubs so that they can, one of the key bits of feedback to me has been they find it very difficult to navigate the planning system, to find the right person to talk to. And so I've certainly worked with the planning minister to ensure they have a central point of contact in order to be able to get that advice in a timely manner and work their way through the system.
And do they have that central point of contact?
There was one appointed at one time. I'm not sure that still exists.
Sorry, Chair.
No, not at all. Any further supplementaries? No?
Madam Chair.
Mr. Braddock?
And I'm happy to allocate my substantive to this because I was going to go down this line and I think it's pertinent now. The CMS is not a new idea, is it, Minister? And I'm happy to table these documents for the committee. The fourth assembly in 1999, the committee reported on social and economic impacts of gambling in the ACT. In the government,
Are you saying you might take that as your substantive? So shall we
Yes.
move on and give you the opportunity to do that?
yes,
Thank you. Mr. Parton?
Thank you, Chair. Minister, when considering measures for the reduction of gambling harm, can I ask what consideration do you give to the leakage of ACT gamblers to New South Wales?
Look, it's a question that does come up often, Mr. Parton. I think the responsibility we have as the ACT government is to do our best to have a model operating in the ACT that minimises gambling harm. And so we have to take responsibility for our own nest, if you like to put it that way. Ideally, we will also work to coordinate with New South Wales. And to that end, I've at various times spoken with New South Wales, and our officials speak with New South Wales. They speak with a range of jurisdictions. I think it's fair to say that New South Wales is probably the most permissive regime in Australia when it comes to poker machine licensing, the least developed when it comes to harm minimisation measures. So that is a challenge for us being surrounded by that environment.
What did we learn as a jurisdiction in this space during that COVID period when our clubs remained closed for quite a number of weeks longer than New South Wales clubs?
Yeah, there is evidence that's been provided that we saw an increase in revenue for the New South Wales clubs during that period. The more anecdotal evidence is people will say a lot of ACT number plates in our car park. The industry has data that I don't have to hand, but they certainly have data on the increase in revenue experienced by its raiders in Queanbeyan during that period.
And so, based on your comments in the previous answer, there's no appetite from you as Minister to attempt a closer harmonisation of our systems, our harm minimisation measures, our practices with New South Wales?
Oh, look, I think there are opportunities. I think there's different questions. There's technical questions. You know, New South Wales has a CMS. We could endeavour to work with them on rolling that into the ACT, for example. There's technical issues there, and New South Wales is changing their operating system at the moment, as I understand it. Their underlying operating system will move across to the same basis as other states in Australia. So the ACT is going to have to move to some extent, I think, anyway, because much of the technical support that we have comes from New South Wales.
Sorry, Chair, just finally then, on the basis of that answer, has there been any conversation whatsoever between this government and New South Wales? You've just indicated that New South Wales is updating their central monitoring system. Has there been any conversation about the potential inclusion of the ACT in that scenario?
I'd have to take that on notice, Mr. Parton, particularly at the officials level when speak with the Minister.
Please, thank you.
Yeah, let me check that. So I know the officials do talk to other jurisdictions at the time, and I just don't know the answer.
All right, thank you, Chair.
No further supplementaries. Mr. Braddock, substantive question.
thank you, Chair. So, as I was saying, the idea of CMS is not new in terms of there's a 1999 committee report which looked into CMS for the for the Legislative Assembly, and the government response says recommendation was agreed in part with further consideration required and estimated the cost of a CMS at $5 million in 1999 dollars. And then also the 8th Assembly in 2015, in the government's response to the Public Accounts Committee inquiry into the elements impacting the future of ACT clubs, said to recommendation 33, and I quote, "To investigate the feasibility of introducing a central monitoring system was agreed in principle by the then Minister Birch on behalf of the government." Can I try to understand, despite 25 years, we still don't have a CMS? Why is that the case?
There's a lot of history there that I'm not familiar with, Mr. Bragg, in terms of before even my time in the Assembly, some of that. But I don't have a clear understanding of why it's not been introduced. Clearly, there's been a sense it should be. Every other jurisdiction's done it during that period, but it's for some reason the ACT has not gone down that path. I think, again, it raises the question of why not, and particularly for Labor, who do have that impossible compromise with the Labor Club owning a lot of poker machines in this city, raking in hundreds of millions of dollars over the last 25 years from the poker machines. The question, a lot of people in the community speculate as to why we've not seen significant poker machine reform in the Territory, but it's difficult to exactly pinpoint why.
Thank you.
Supplementary.
Dr. Patterson.
As Mr. Braddock sort of outlined the history of the CMS discussion in the Assembly, and as was the starting premise of the question, that this has been implemented in most Australian jurisdictions for many years, yet the rate of gambling harm is consistent across the country. So why, Minister, do you believe that a CMS is a value for money harm minimisation tool?
Dr. Patterson, I am not asserting, I can only say this to you so many times, I am not asserting a CMS is a harm minimisation tool. All those other jurisdictions have a CMS and not put the harm minimisation tools on top of them. But you can't put the harm minimisation tools in place unless you have the machines linked together. I've explained that numerous times in this committee.
So
I cannot be any clearer about it.
Just to be clear, so you can't have any cashless gaming without a CMS?
Oh, you can have cashless gaming without a CMS.
With harm minimisation measures?
Well, that's a matter of... Look, it depends. And if you can bring in a half-baked system, like the one that you've put on the table, where people will be able to get around it, and it will have all sorts of loopholes in it. If you want to do this properly, do it. If you want to do it properly.
And what's the cost of doing it properly?
Well, that's what the government is seeking to establish at the moment. I do note that the alternative policy that's been put on the table by the Labor Party has not been costed. But it has a minimum cost of $37.5 million in today's dollars to retire all the licences they want to retire. Now, that's not been costed, and I know Dr. Patterson's also put a model on the table for an untried and untested and unused digital wallet, and there was no costings on that either. So in all of this discussion, I think we've got to have some sort of apples and apples conversation, and that's not being had by the people putting forward an alternate proposition.
I'll have a... Oh, yeah, Mr. Braddock?
You mentioned that minimum of $37 million costs. Who would have to pay for those costs?
That comes straight out of the ACT government's coffers. That's the model. The model that's operated here for machine reductions in recent times has been the government has paid for each licence that's been retired. Government currently pays $15,000 a licence. Now, I'm aware that the clubs are concerned. Well, the clubs hold the view that that's not enough. They want to see that number go up. And so that's why I say it's at least $37.5 million. If you want to retire 2,500 more licences, it's going to cost at least $37.5 million.
Or 20,000 if the whole club goes, 20,000.
Well, that's true, Mr. Parton, if the whole club goes. Now, in that, this brings us back to the Labor Party's impossible compromise. The Labor clubs would receive millions and millions of dollars under that process for retiring those licences.
Commentary?
Yes.
Do you oppose the surrender of the licences?
What I'm supportive of is reform that is proper reform that will actually deliver true harm minimisation. Under the proposal that's been put forward, 13 years from now, there'll still be 2,000 poker machines operating in this territory with no controls on them. Yeah, so if you've got a gambling harm problem, you'll be able to go around and find a machine somewhere that has no limits on it. You can just keep gambling your family savings away Whereas the model we've had proposed, under the market sounding, can be in place in 2 years if Cabinet authorises the go-ahead of the procurement process.
Minister, you've got legislation before the Assembly to reduce the machine numbers for exactly the cost you said for the 15,000 or 20,000.
Yes.
Do you think that's not enough for clubs?
No, well, that's the price that we're currently able to, that's what we've put on the table, and that's a voluntary surrender scheme.
And you think that's a sufficient amount?
Well, clubs are retiring them at that price at the moment, but I know that there is agitation.
Could I have a supplementary? Yes, I can. Following up on Mr. Braddon's point.
You're the chair, you can do it.
Can I answer
You
my
have a question, you can do it.
We'll call it a rhetorical question.
So, is my understanding correct? It appears we had a committee inquiry in 1999. Since then, under, unfortunately, vast time of Labor government and even a significant time of Labor Greens government, we have not progressed much further. And in the meantime, the Labor clubs are raking in millions of dollars from poker machines. Is that a fair summary, do you think, Mr. Rattenbury?
Yes.
Thank you. Any further supplementaries? Moving on.
Actually, can I just make a comment? I know there's a lot of conflict of interest. I'm a member of the Labor Party. So,
And the Labor Club too.
Just in case you weren't aware. Good. Glad we've established that. I think there's a lot. Yeah, there is. There's a point of order, Chair. I'm not sure what it is, but I'll say it and you can figure it out. I think there's a lot of comment on the Labor Party's relationship to poker machines, and I think a number of the commentary, as I've alluded to previously, isn't quite understanding the situation or the nuance of it. And I would just ask Chair, noting that you're not meant to mislead anything.
I think since you made that point, everyone's been very careful to talk about the Labor Club.
I think people have still not quite getting it. So
moving on,
just bear that.
Mr. Braddock's question. I think it's Dr. Patterson's substantive question. Yeah. Bit of restraint, Dr. Patterson. Do you have a substantive question?
I reckon she will.
Yes. Okay, sorry. So, Minister, part of the Greens election platform talks about government action on gambling must be independent of industry bias. I would like to understand, so the market sounding for the CMS, Tasmania, for example, their CMS is a Tabcorp company, subsidiary, Max Gaming. It's likely that I would suppose that any CMS provider will be a gambling industry business. I was wondering, does it align with your party's values to be handing over all of the ACT's control of EGMs to the gambling industry?
Dr. Patterson, I think this is the importance of the work we need to do to put in place legislation, privacy controls and other restrictions to ensure that the scenario you suggest doesn't occur.
So has legislation been developed?
Not at this point in time because Cabinet's not authorised the development of that legislation.
And how long do you think the development of that legislation and the implementation of a CMS would take?
As I indicated earlier, the market sounding suggested it could be done within about 2 years.
Okay. And previous advice was talking like 5 years?
That was based on, that wasn't a technical, that was around if all machines had to be replaced, it would take longer. And so again, I guess the good news is we can do it faster than we thought.
Thank you.
Thank you. Substantive question. I'll pass mine to Mr. Parton.
Thank you, Chair. Minister, as the responsible minister in this space, can I ask you what are your thoughts, and I know you've already flagged some of them, but what are your thoughts on the Labor proposal to quickly ramp up machine reductions in the ACT? What effect would these changes have on, for argument's sake, the viability of our club sector?
Point of order, are you seeking an opinion, Mr. Potter?
Look, I mean, Ms. Orr, I
I
mean,
think the minister could probably answer for himself whether he feels that's asking for an opinion.
The feedback I've received, rather than my opinion, perhaps to stick within the standing orders, the feedback I've received certainly is that, and this is publicly available information which I can reflect, the clubs have indicated this would dramatically dent their viability. They don't see this as a pathway that enables them to continue to operate. So that's the feedback they've given to everybody. I think all the parties have received that letter, so I'm not sharing it. It's not wrong.
There's public feedback.
so they're talking closure?
Certainly they've indicated that to me in conversations, yes.
Do you believe that if this policy, if implemented, do you think it would result in the increased leakage of ACT poker machine gamblers into New South Wales?
I think it depends how it would operate. You know, there'd still be, for many years, many poker machines in the ACT. You know, as I said, in 13 years' time, there'd still be 2,500 doing their thing. I think that people who are committed to getting on a poker machine are still going to find them. It's also unclear what the model would look like. And it talks about cutting to 1,000 machines. What we don't know is whether that would result in a couple of super venues across the city. You know, might be the Labor Club and the Southern Cross Club become the duopoly poker machine providers in Canberra. For example, big clubs, mini casinos, or whether there be 15 venues with 60 machines each. It's unclear what the model would be.
And under a scenario where more and more problem gamblers are skipping across the border into New South Wales, which jurisdiction would take carriage of providing the support services for those ACT residents who were experiencing gambling harm? Would it be New South Wales or would it be us?
I doubt New South Wales would take that. The residents of the ACT would, you know, all the consequences we know of gambling harm, whether that's family violence, issues related to affordability of rental properties, marriage breakdown, all of those services would be delivered in the territory.
Thank you.
Supplementary, Chair?
Yeah, Mr. Braddock.
In terms of Labor's proposal, how much of that 37 million we were talking about earlier would probably end up with the Labor clubs through the surrender of the machines?
Mr. Braddock, at, 443 licences at currently $15,000 a go. Now, whether it be all of them is a question. As I say, under the model, they might not get any because they might end up become the club with all the machines, depending on how the model was rolled out. So it's anywhere between 400 times 15,000.
Okay, thank you.
6 million.
Yeah, 6
odd million.
We've done the maths on it.
Through to, scenario 0 to 6 probably.
And what has been the feedback from gambling harm reduction community sector people to that proposal?
I think there's genuine disappointment. I think there's, to be fair, I think there's some relief that we're finally seeing a reform proposal from the Labor Party in the gaming machine space after years of being impossibly compromised. But I think there's also frustration that there's actually a good model before the government at the moment that's being undermined by this proposal. I think people see this as a deliberate political attempt to sabotage the reform that's currently in place or currently being developed. What the advocates have been very clear in their public comments that they believe models that have universal player card gaming and limits attached to losses is the gold standard, the best way to deal with harm minimisation. People who have spoken publicly about this, who've spoken publicly about their gambling harm, have said under this model, I would still be able to find a club where I could keep going with no limits and have the same outcome I had before.
Thank you.
Thank you. Ms. Orr.
I am happy.
Addison.
Thank you. Speaking of the advocates for gambling harm reform, in a recent FOI, it talks about probity information for a visit to Crown Casino and mentions many of these advocates. Did they go on a trip with you to Crown Casino?
I was invited by Crown Casino to go and examine their carded play system. They invited me to bring observers, and so I did indicate to any of the harm minimisation evidence if they wanted to come with me, because I know they had some concerns and scepticism about the model, and I thought they would find it valuable to learn more about it. So yes, some did attend.
There was no move to bring any of the club sector here, given that they would be the people who have to implement it?
No, my view was that they've sort of invited me on similar trips, so I felt that they probably had the knowledge. I think so yes.
And given Crown's system is not a cashless system, you still have to feed cash into machines to play. What did you learn from your visit?
No, I think Crown are using a carded system.
You have a card, but you still have to, that has your limit on it, your pre-commitment limit and your time limit, but you still play with cash.
I'll double check that, Dr. Patterson. I'll take that on notice.
So you went and met with them and you don't know what the system
I've got a
is?
mental blank right at this point. I'm surprised, but I'm going to double check.
Okay, and given that Crown is not a part of Victoria's
So just
CMS,
actually on that, they were very clear to me that it was all about the card. The conversation we were having was about the card and carded limits. I didn't actually go to any machines. That's why I can't. Why can't I think of the answer to that question? I didn't actually go to the machines. We much more talked to them about the cards and that sort of thing.
Can I just clarify? My recollection there was you just said you'll check, but will you actually take that on?
No, I've actually, with a slightly more time, I won't take that on notice. I think I've now answered Dr. Patterson's question as to why I couldn't answer that, because I didn't actually go to the machines. I didn't see anybody play a machine, so I didn't get to the point of asking that specific question, or observing that behaviour, which is why I can't answer the question.
so many of the sort of probity information check that was done on that trip talks about learning about the capability and opportunities of a CMS to support reform here in the ACT. The Crown is not part of Victoria's CMS. Like, that's part of the problem with Crown. So I'm interested to know what you did learn about their CMS.
Well, they invited me to come and examine their harm minimisation and card-based play model. That's if I recall the letter correctly, that's the offer they made, and that's what I went to learn about.
And given that that seems to be the model that you're pushing, the fact that you don't understand how it works or what it's about doesn't seem like that trip was very, very beneficial.
Well, I dispute that. I think you're being patronising to me. So I indicated what I went there, the discussions that I had. It was very valuable. I think the other participants of the trip found it very valuable. There were public servants who went with me on that trip. There were a range of conversations that took place and various people got various bits of information.
So what was the value that you bring back to the ACT from that trip?
A range of things. What became very clear is I think Crown talked about how long it took them to put the measures in place. Some of the challenges they'd found through that. They also talked about the limits of not being part of a joined-up system. They explained the fact that the measures they put in place were being undermined by the fact that people could walk out of Crown and go across the road to a pub that wasn't connected to a limited system. And that's very much driving my thinking, is it exposed the flaws of having a proposal where you can have just a digital wallet for each venue, which is essentially what Crown has.
They don't have a digital wallet, but anyway.
Well, a card-based play system that's restricted to their venue is what I meant.
Mr. Braddock has a supplementary.
Just a question. Is the Crown model what you're looking to implement here in the ACT, which I thought was meant to be a multi-venue system?
I'm not, we've been dragged into a conversation about Crown. I'm not saying the Crown model is the one. I'm just saying, the line of questioning was, I went there, we learned some stuff from that visit. It's informing our thinking, but we're not seeking to copy what Crown has done. There's certainly valuable insights and lessons from their model.
Thank you.
Any further supplementaries? No. Moving on, Ms. Nuttall.
I also refer you to pages 40 and 41 of the 1999 committee report. This is not about the CMS, just to be clear. It recommended, because of what is on my reading, problems with the use of the term gaming, and I'd certainly agree that the then proposed Gaming and Racing Commission be renamed as the AC Gambling and Racing Commission, which ultimately was. Do you know if there's a reason why that advice wasn't also applied to the title of your portfolio?
No, I don't. No. But certainly what I can say in response to that is that I've had we work very hard to think carefully about the right language. We've received representations during this term from advocates about the right way to describe both the portfolio, the activity, and how we speak about individuals and their interaction with the gambling system.
What would you say, sort of, are there lessons to be drawn from our discussion about, like, the appropriate terminology? Are we talking specifically about gambling harm reduction as opposed to mentioning gaming in the context of harm reduction?
Sorry, say that again?
Do we have lessons that we can draw from the terminology, for example? Are we erring towards gambling harm reduction as opposed to saying something like gaming harm reduction? Is there a sort of...
Yeah, I think on that specific terminology, the concern with gaming is gaming sort of sounds like saying kids too. It sounds a bit, what's the right word? Benign? Sorry?
Does the ACT government have a policy on video games?
Yeah.
I'm being funny.
Yeah, no, it's
trying to lighten the mood because it's been
Thank
quite a robust one this afternoon for a Friday after 2 weeks of estimates.
Yeah, I think the concern is gaming sounds more benign, and describing it as gambling is more realistic about what it actually is. That's the sort of example of why people have a view on the terminology.
But you know, have minister. No, I'm not even going to. It's 2 weeks. For 2 weeks.
We'll save it.
The answer is no.
Ms. Nuttall, do you have further supplementaries?
I don't, no.
No. Mr. Parton?
Thank you, Chair. Is there a report out from ANU in June this year? Gambling participation and risk, specifically after COVID-19, an analysis of population representative, and it's got a longer title than your list of portfolios. But if you want to summarise in a sentence, it indicates that certainly under a prohibition model, or under a prohibition model, that we do see and we will see people gravitating extensively to online gambling. As the minister responsible in this space, what ability do you have, if any, to intervene in regards harm minimisation for large sections of the population that are gravitating to online gambling, as opposed to how much influence you have on poker machine gambling harm reduction?
Oh, look, I think this is an area of real concern for me. We're obviously seeing a significant increase and trend towards various forms of online gaming. The ACT has limited ability to regulate that in that space. We are part of the National Consumer Protection Framework, and through that we have done our part to implement the measures that each jurisdiction is required to do under that. So that's sort of been a combined Commonwealth, States and Territories effort, and that has a range of things in it that have, and we can go into those measures if you want to.
No.
Yeah, I won't. And then of course we've seen the inquiry that took place in the House of Reps, which has recommended a range of actions that largely require the federal government to move in that space. So I guess the way I think about it is, as the ACT government, we have particular responsibility to deal with gaming machines because they sit in our regulatory space. The federal government has the bulk of the responsibility for online gaming, but we need to work together on that one.
So the short answer is very little in terms of your ability to intervene in a harm minimisation area with online gaming. You've got very little ability to intervene.
Yeah, Mr. Parton, probably just the contribution I'd make to that is that the Territory's restrictions relate to its ability to influence regulators based in our jurisdiction, and so much of the online gambling advertising, for example, activity that you might see occurs by way of organisations which are based outside the ACT, and so our regulatory levers affect our one licensee. In terms of future reform plans or objectives, probably that speaks to the importance of the National Consumer Protection Framework, and that where jurisdictions have agreed to a national minimum standard reform agenda, which is what occurred under the previous National Consumer Protection Framework. That is what drives the activity across all of the jurisdictions in a consistent way. And so I think recently the Commonwealth has indicated that they intend to conduct a review of the now implemented National Consumer Protection Framework. But hopefully that gives some kind of colour and movement to kind of the restrictions around the territory's ability to do things.
Yeah. All right. Cool. Thank you.
All right, Mr. Braddock, do you have a substantive question?
I do. And moving on to fair trading. The Commissioner of Fair Trading was recently given powers to fine businesses and traders who fail to attend scheduled consumer conciliation for consumer claims of less than $5,000. I'd just like to ask, are you planning or expecting to utilise this penalty often, or what is the purpose of that penalty?
Just bear with me, Mr. Braddock. While my officials are joining me at the table to give you a bit more data, you may recall a couple of years ago we legislated to create a power for the Fair Trading Commissioner to be able to mediate disputes between consumers and businesses for issues under $5,000. The idea here was sort of using the model, again, perhaps like the Human Rights Commission operates, where they're able to bring people together to use their powers to get an outcome and avoid potentially having to go to court. That reflected actually a recommendation from the Productivity Commission in their inquiry into right to repair. We've actually already done it by the time the Productivity Commission came out with it. What we've found is that in some cases businesses are simply not turning up to that mediation despite the requirement to. And what this new legislation does is put in place a power for Access Canberra to issue a infringement notice for that failure to attend. Previously, they would have had to actually go through the court system to enforce that right. Perhaps my colleagues might have some numbers on how many examples there's been or anything like that they'd like to add. Or I've just put them awkwardly on the spot.
Sorry, we're just trying to get ourselves sorted here. Louise Bassett, I'm the Executive Branch Manager of Fair Trading and Compliance. I have read and acknowledged the privileges Friday afternoon privileges statement. Thank you for the question. We have had no infringements issued at this point. We have, however, during the period of introduction of the new infringement process, been focusing our efforts on early resolution and engaging with traders to come to conciliation or a settlement with the consumer in question. And we have had some success at reducing the lag time, I guess, for those consumers who've been waiting for an outcome from a result from a trader.
Is it driving successful outcomes, at least having that on the books?
I think it assists us because it gives us another regulatory instrument to use should a trader be unwilling to participate in a compulsory conciliation or early resolution processes. So Access Canberra undertake a range of contact and early engagement with traders who consumers are having issues with. And we try at the beginning of that process to make sure that the two parties are discussing at least what's on the table by way of resolution or what they're seeking so that we can attempt to bring them together in that conciliation process. Sometimes we are unsuccessful because either the consumer's expectations exceed what the trader is willing to offer or the consumer does not have satisfaction from what the trader's offered. So there are some challenges in that one, but we certainly have had some success at bringing the matters together and the parties together quickly so that we can provide early resolution. It becomes more complicated when matters drag on, as you might imagine.
Thank you.
If I might add just briefly on that, I think that's the important point. There have been examples where we have been able to get an earlier resolution for consumers, and that's been the very point of this, is to try and provide a less expensive, faster and less confrontational pathway.
Thank you.
Moving on, Dr. Patterson.
Thank you. Minister, you speak, we've spoken a lot about your view on the importance of having a universal limit set on poker machine expenditure across the ACT. What limit are you proposing?
I think there's some room for flexibility on that, Dr. Patterson. There are a range of views around. Certainly, we've spoken before about the Tasmanian model. There are views of taking a different approach. Various advocates I've spoken to have different numbers in mind, so I think this would be part of the development of a final proposal.
Or a CMS?
for a carded play system with a mandatory pre-commitment built into it.
Okay. Will you disclose to the public what you think a limit should be prior to going through any procurement process for a CMS?
Well, I've certainly indicated I think the Tasmanian model of $5,000 a year seems like a good starting point. Now, there's debate about whether there's a number of models you could take, whether the government should mandate a limit, whether the government might just put in place an advisory limit. And again, there are mixed views on this. I think it's the right sort of number. Now, you've previously commented you think that number is still a lot of money for people to lose. I agree, but at the moment there's no limit. Now, if all the parties in this place were minded to go for a lower limit, given you suggested that one's too high, that's a discussion we need to have, but I think it would require a legislative response, which will require a conversation in the community and some agreement amongst a majority of members of this place.
Minister, do you not think it would be better to follow the evidence base in terms of low risk gambling limits, which says between $380 and $615 per year as a max limit to address gambling harm?
Look, Dr. Patterson, I think if I brought that proposal forward, nobody in this place would support it. I don't think it would pass the Assembly.
So if the importance is so much on reducing harm for a central monitoring system to implement universal limits, why would you not follow the evidence base of the limit which they suggest, the research suggests it should be? Why would we just pick out numbers that we all feel good about when actually the harm would still continue?
Oh, because I think, again, if you look at the reality of this Assembly, we know where the Liberal Party stands on these matters. The Labor Party continues to be impossibly compromised by its associations to this industry. And so I just don't think a number like that would actually pass the Assembly. If you're prepared to sit here and say to me, the Labor Party will get behind a number like that, well, that's a conversation we should then have.
But don't you think we should know where we're going before we would purchase a CMS for the ACT?
Well, I am trying to advocate for a position that has mandatory pre-commitment of gambling losses.
At what level though?
And player card gaming at a level that we can agree to.
Yeah, but that's not going to reduce harm. That's the
I
thing
can have
that
any number I like, but if the Assembly will not support it, it's going nowhere. So we collectively need to operate in the best interest of this community to try and get agreement on an outcome.
But if it's not going to be effective, then why would we do it and spend millions and millions of dollars doing it if it is not going to reduce harm?
Well, the evidence is it will reduce harm.
At what limit?
Well, frankly, at any limit other than it's unlimited at the moment, we're going to have an impact.
So what's wrong with individuals setting their own pre-commitment levels within venues? Why do you need a very, very expensive central monitoring system if you can't articulate what harm you're trying to address?
I am trying to address the harm that at the moment Canberrans lose more than $180 million a year to poker machines in the ACT. Now that ripples through families, it ripples through communities, it ripples through workplaces where we see fraud by staff who are trying to pay for their gambling harms. You talk about this being expensive, it is not expensive compared to the losses that are going in this community every single year. The best advice I am receiving is that putting in place a system that will allow for player card gaming with loss limits attached to it will be highly effective in reducing gambling harm.
Minister, what have you done in the last 4 years to reduce gambling harm for families in the ACT as Minister?
Well, I've worked incredibly hard to put in place this system.
It's not in place. We are so far from it.
We are far from it, and that's because it is being stalled in the government decision-making process. I would go so far as to say that my cabinet paper has been given the go-slow treatment. You can see from the FOI how many times that has gone before the cabinet, how long it's been.
How many times has it gone before the cabinet?
What dates? I'll have to take the number on notice and I'll have to check that.
Because last time we spoke in the hearing, you said once you brought the proposal last year in November.
If we include the subcommittees, I can give you those numbers. But it's since September last year, I've had this proposition before government.
Chair, I've got one more question.
Mr. Parton,
I'm sorry, I'm not, I don't know if
Oh,
Dr.
a
Patterson's-
question.
Yeah, I don't have a supplementary.
I think Mr. Palmer's saying you'd like to get a question before the 3
Right,
minutes.
yeah, okay. Are you done?
Yeah.
Okay, Ms. Smart, why don't you have my question?
Thank you. Minister, earlier in the term, we had a bill regarding creating heat and smoke refuges in clubs, which Dr. Patterson sought to, quote, improve with some amendments. I just want to know what the take-up has been in terms of how many clubs have indicated a willingness to participate, because, you know, obviously we've gone to great lengths through that legislation. How many people, how many clubs have put their hand up to participate and be a part of that?
So far, 3 venues, Mr. Parker, is the
Three?
advice that I have, yeah.
Okay.
Look, I think this is one of these things, we've also had a couple of benign years, frankly, that this proposition was put together in the aftermath of the Black Summer in 2019-20. What we saw at that time was that the extreme heat we were experiencing and the smoke, people didn't know where to go. They were being literally smoked out of their own homes, and we were looking for opportunities for places that people could go when they were so desperate in their own home that they felt they needed to escape to somewhere cooler and with cleaner air. And so that was the context. Now, I think the couple of benign years has probably taken the focus off that for some people. I am pleased, though, that we have a model in place that if we start to see that come back, we can activate it. And I'm grateful for those 3 venues that have already signed up.
It's just been, I mean, I've had suggestions from venues that I won't name that are of the belief that the legislation is a little too restrictive in the real world for them to participate in.
Well, I mean, the amendments proposed are far more restrictive. The amendments proposed by Dr. Patterson sought to close down both the gaming machines and I think the bars while they're being used as... Now, the reality is those clubs would be open normally and people would go there at normal times anyway. What we did seek to do was put in place a model where people could, the area that was sort of set aside as the refuge, and we know these clubs, they've usually got a big auditorium type space.
Yep.
They be separate to the gaming area, so there's a clear delineation of the refuge from the normal business of the club. I think that we sort of strike a practical balance there.
That's enough from me, Chair.
Yep, our time is up. Perfect timing. On behalf of the committee, I thank our witnesses for attendance today. It was very entertaining. If you've taken any questions on notice, please provide